afternoon. May it please court, counsel. My name is Melinda Nye, and I represent the defendant, appellant Darian Love, in his appeal from his convictions for willful injury, causing bodily injury, and assault with intent to cause serious injury. After an altercation between Mr. Love and his girlfriend that lasted the better part of a night, Love was charged with 3 offenses: kidnapping in the first degree, attempted murder, and willful injury causing bodily injury. Love proceeded to trial. He raised defenses of justification, intoxication, and diminished responsibility. At the end of trial, the jury acquitted Love of kidnapping. They also acquitted him of attempted murder, but found him guilty of the lesser included offense of assault with intent to cause serious injury. He was convicted of willful injury causing bodily injury. At sentencing, he argued that his 2 convictions should merge. The district court did not merge the 2 offenses, but instead enter judgment and sentence Love on both counts. He appealed, raising that single issue, whether his offenses should merge pursuant to Iowa Code Section 701.9 and Rule 2.6 sub 2. The case was transferred to the Court of Appeals, which affirmed his convictions, concluding that because there was sufficient evidence in the record to support a finding that Love committed more than 1 assault, that the conviction shouldn't merge. And of course, Love has requested further review, which was granted. As I mentioned, the argument on appeal is a narrow one. It's whether the convictions for assault with intent should merge into his conviction for willful injury pursuant to Section 701.9 and Rule 2.6. He's not raised a sufficiency claim. He's not raised a complaint about jury instructions.
So it's your position, Ms. Nye, that, as I understand it, basically you have to, in one of these sort of continuous act or continuous event situations, unless you have a jury finding that based on the standards we set forth in Ross and Velez in those cases, unless there's a jury finding of that the 2 acts are separate, you have to merge them. Is that your position?
That's correct. That's the argument, and that's what this court and the Court of Appeals has done since the 80s when faced with merger arguments. On merger tests, starting with more recently Anderson and Lambert, and again, like I said, back to the 80s, it's been a purely legal analysis, and it starts with a comparison of the instructions given to the jury and the elements contained in the instructions. Do they meet the Blockberger test? Is it possible to commit the greater offense without also committing the lesser included offense? And in fact, within those cases, you can look at some of them, such as Anderson more recently, where the facts of that case would indicate that more than 1 assault took place. And the court didn't go into the facts, didn't consider how many assaults might have taken place, but rather did a pure legal elements analysis and concluded that the offenses should merge.
Well, let me just clear the brush here. I think there are 2 propositions that everyone agrees with, and maybe not, but I'll test them. One is that under the record of this case, the facts at trial, a jury might have concluded that there were separate acts. In other words, there was substantial evidence from which a jury could find separate acts. I think everybody concedes that. I also think everybody concedes as a general matter that these 2 assault crimes, willful injury causing bodily injury and the lesser assault crime, are lesser included offenses as a matter of law.
Right.
The question is, I think, what was a jury asked to do and what did they really do? And you know, I've looked through the instructions, I've looked through the verdict form, and in particular I'm interested in the verdict form, which is characterized as 3 counts, as you know. Count 1 has to do with kidnapping and related offenses. Count 2 begins with attempted murder and lesser included offenses, and then count 3 has the 2 assault crimes, 3 actually, and then a possible. Now, I guess my question to you is, what does this mean, the way the jury verdict was framed? did it allow a reasonable jury to say, well, under count 2, we're going to find assault with intent, and under count 3, we're going to find willful injury, and therefore the jury found separate crimes? What do we have?
I don't think that's an assumption you can make. There's a difference between deciding whether there was sufficient evidence that a jury could have found multiple acts, the application of Velez or Ross into this case, and deciding that it's about sufficient evidence. The jury only had to find, we don't know what the jury believed. The jury could have believed that every single one of these various assaultive acts occurred. It could have only believed that one or two of them occurred. We've got conflicting testimony. We've got defenses raised. So the jury could have believed his defense. They could have believed that none of this happened. You don't know. And so the question is not necessarily even what the jury could have found, but it's what the jury actually rested its verdict on. The jury might have believed that 14 different assaults happened, but they might have rested their verdict on the same act, assaultive act, and there's no finding.
I think you raise a valid point. My question now is, so to avoid this problem, so we don't get this in the future, let's say you're the prosecutor and you want to get 2 convictions. How do you charge the jury?
It's simple, and this is what's happened in this line of cases involving kidnapping and sex abuse. There's a line of those cases where particular sex acts have to be charged in the marshalling instruction. You identify the particular sex act or the time or the date if there's...
And once the court does that, isn't the court finding as a matter of law that they're separate acts, and shouldn't that be a jury determination?
If that's the way the case... that's what happens all the time in these other kidnapping and sex abuse cases. The state brings the case it wants to bring, and if it wants to allege that a particular assaultive act constitutes one assault and that this course of conduct is actually several repeated assaults.
The question is it up to the trial judge or the prosecutor to kind of break it up into discrete pieces that it thinks meet our Velez and Ross standards, or do you instruct the jury on the Velez and Ross standards and they have to decide whether the acts are separate?
I think that's definitely, I think what would happen is the state would submit jury instructions which identify the discrete acts, and then defense counsel didn't believe that they met the Velez factors, then they're going to have argument over jury instructions. It's possible another way is to give the jury the Velez instructions. I'm not sure that that's, sort of as a separate instruction that you must base this on separate acts. That would be another way to approach it. I think, though, that what's already happening in other contexts and not in specifically assaults are that the state is proposing that these are separate acts.
Wouldn't that work in some circumstances, but not necessarily in all circumstances?
I'm sorry, say that again.
Wouldn't that work in some circumstances, but not necessarily in all circumstances? So I'm thinking of, I think in this case where you have an attempted murder charge, there could be all sorts of independent and discrete acts which might convince a reasonable fact finder beyond a reasonable doubt that this person was attempting to commit murder. Mm-hmm. It may just not be a slap or a punch or this or that, but when you accumulate all of these, wouldn't that, so it might work in that circumstance, but mm-hmm. It's not going to work in every circumstance, is it? Be able to instruct on discrete offenses or charges. I think
in that case, then you could have a separate instruction that tells the jury that the basis of, or clarifies whether if it's finding a separate act to support or series of acts to support their finding of attempted murder. It's always going to depend on whether they're going to actually merge or not. How, this sort of...
If you had a special interrogatory that said, was your, you found willful injury, was that separate from the, with appropriate instructions, was that separate from the prior assault on or attempted murder? And I guess it would be resolved. Yeah. I'm not sure there's a model instruction that works in every case, I guess. But I think I gather it's true that there are no instructions of any kind on Velez type thinking in this case.
I don't think so, not yet.
I have a more basic question, and this has been bothering me. If I read the information, mm-hmm. he's charged with 3 different counts and a factual. I don't have the minutes here because the minutes weren't put in the appendix. The problem is, do the minutes of this case have a factual basis for separate acts? Or is it the same act that they're charging for each different count? Because it seems to me if the county attorney's only charging one act, and he could have all the different crimes he wants, but he was only describing one crime in the, or she, I don't know if it's he or she, in the minutes, how can the jury come back with separate crimes if the person's not charged with it? So tell me what the minutes show us.
The minutes show, sort of essentially the same recitation of facts that came out at trial, that this was an all-night altercation. There's no, it was sort of, it really was. I sort of disagree. The state had argued that this was argued as separate and distinct acts. I disagree that that's how this case was tried. Certainly not in the jury instructions, but not in closing, and not in the minutes. There are facts that if you took each one in isolation could arguably support a separate
And if you went all
assault.
night, you can have an act that occurred before midnight and an act that occurred after midnight, and no one's separated out. They only have one date here.
Right, there's only one date.
That's what's bothersome to me, but I haven't seen the minutes.
I'm sorry that they weren't included in the appendix, if that would have been
And I'm
helpful.
trying to figure out if they only charge one act, how can we find them guilty of two acts? They have different crimes, but if it's only based on one set of facts and one act, tell me where I'm wrong on that one. And I'm gonna ask the state the same question.
No, I think that's exactly the problem. That's how it's in the jury instructions. It's an act, and so there's no way to know. And it was the state argues in closing that there are these various acts that could support an assault charge, but there's no attempt to say under count one we're talking about when he punched her in the face, and in count two we're talking about fingernail polish being poured. There's no attempt to distinguish. It just says, look at all these things that happened through the course of the night. Any one of those could be an assault, and then there's a reference back to that when you get to count two, and when the state gets to count three, they refer again back to choose any of these you want, and they'll suffice. So there's no attempt to ask the jury to distinguish.
Counsel, on this record and the way this case came to us, is our choice to affirm or require merger, or is another option to remand for a new trial and with our new guidance that they ought to have a Ross-Velez type instruction?
I think under the existing law, it's merger or affirmation. But that's a good point. I'm not sure, I guess. I haven't
It
thought
seems
that
like
way.
we ought to encourage the use of a special interrogatory if there's, and that, I don't think it'd be that hard to write a jury instruction that would set forth the Velez or Ross factors. But in this case, as I understand it, neither the state nor the defense asked for that instruction.
No.
So I don't know if we can remand for a retrial.
Defense wouldn't want
And
it,
I
I
think
don't
it
imagine.
happened before Velez. I think the case was tried pre-Velez.
Is there anything in the record to indicate how the county attorney argued the case in closing argument?
It was, as I described, it's the county attorney starts with count one, and part of that involved an assault, and so the county attorney identifies multiple acts that any one of which could constitute an assault, and you, the jury, have to figure out what you believe. And then when he gets to count two, he again refers back. He's like, we've already talked about assault. Think about what I already said. There's lots of things that could be an assault. And then when he gets to count three, again, there's a reference back. So there's no attempt to distinguish or attach certain acts to particular counts of the instructions. I'll stop for there. For those reasons, we ask that the court vacate the decision of the Court of Appeals and vacate his conviction for assault with intent and remand for sentencing only on the willful injury charge. Thank you.
Thank you, counsel. Ms. Hall?
May it please the court, counsel. The defendant has asserted that this is a merger case, but we believe that as he frames it, that he's actually challenging the wording of the jury instructions and/or the lack of special interrogatories. Because error was not preserved at trial on that ground, a jury instruction claim would need to be raised as an ineffective assistance of counsel claim. The Court of Appeals did not note or address an instruction claim. One of the cases cited in the defendant's notice of additional authorities, State versus DeLapp, in that case, the Court of Appeals considered an ineffectiveness claim based on counsel's failure to seek instructions that would require jurors to find more than one assault occurred in that case. We note that the court found no prejudice in that case because the evidence had detailed several confrontations over a period of time. The defendant was charged 2 offenses in separate counts, and the jury was instructed that they needed to determine the defendant's guilt separately on each count.
Yeah, can I
That-
back
that
up?
sounds-
Can I back up a second? We said in Ross and Velez, and I know it was after this case, that the county attorney has the absolute right to charge as many offenses as he or she thinks he can prove. Charge them separately, and then the jury is going to have to decide whether it's a continuous offense or a single offense. And I know this was before Ross and Velez. The problem is, and I asked your opponent, is when I look at the charging document, he only charged him with 1 act. Now, he said that 1 act created 16 different crimes, or how many they're listed in there, 3 counts of crimes, but never charged the defendant with more than 1 act. So how, and that's what we said in Ross and Velez, a separate act has to be a separate crime. And I don't have the minutes, so maybe the minutes clarify that. So how do we get to 2 separate acts when he wasn't charged with it? Aren't there constitutional problems if we start doing that? That he's charged with 1 act and now he's found guilty of 2?
No, Your Honor. I believe that the prior case law has discussed whether or not the case was actually presented, tried in a manner where the jury could find a series of assaults or whatever the act was versus 1 continuous course of conduct. And our argument is that this case was, in fact, presented as a series of assaults.
I don't think that necessarily gets the state out of it. See, here's the concern, following up on Justice Wiggins is asking. I can understand if you had the jury throughout the trial, there were 2 separate assaults that were argued separately and instructed separately to the jury, and then there's 2 convictions, then clearly you don't do a merger. But where you have a lot of the evidence shows brutal conduct on the part of the defendant toward the victim over the course of an evening, but not really separated at all for purposes of the instructions or the arguments to the jury could have relied on the same conduct in the 2 convictions. And if the jury could have relied on the very same conduct, don't we normally merge? Isn't that what we normally do if it could have happened?
No, the state would disagree. If you look at the cases that have dealt with the issue of whether or not the case was tried and presented in a manner that you could find more than 1 act, the cases that have reversed have been ones that involve more of an alternative theory, like a kidnapping charge or burglary or robbery, and then maybe a sex abuse. For example, we would have had that problem in this case had the jury come back with guilty on first-degree kidnapping, of which we had submitted 2 alternatives, the intent to seriously injure or the intent to secretly confine. And then if they'd come back with the lesser of attempted murder, the assault with intent to inflict serious injury, then we wouldn't necessarily know which alternative they found on the kidnapping, and then was there another assault. But we think...
isn't there a fundamental constitutional problem if the jury could have convicted me twice for the same conduct? If I was convicted of willful injury and assault with intent to commit injury, and the jury in their own minds was relying on the very same specific act that Mr. Love did to the victim, wouldn't that be doesn't that strike you as a constitutional problem?
No, it doesn't, based on the case law to date.
Merger's based on double jeopardy. And you got a double jeopardy problem there. You're getting convicted for the same crime twice. And we don't have merger in Iowa outside of the double jeopardy area. And I think we made that clear in Ross and Velez. And And that's where that comes in. And our statutory merger is a double jeopardy protection. And if you could use the same assault for two separate crimes, you're getting, as Justice Mansfield said, you're getting dung for the same act, but two separate punishments. And without the judge separating it, or the county attorney whose burden is to separate it, which assault goes to which action and which assault goes to the other action, we're left to guess here of what they did or didn't. And I again raise, and I'm sorry to interrupt you, Justice Mansfield, but I have those constitutional problems. And how do you do that? How do you get around, I hate to say get around the Constitution, I don't want to see my name on a bus again, but how do you get around those constitutional problems with this situation?
Well, if you look at what this court did in Velez, the assaults in that case were somewhat similar to this case, where there was multiple assaults, but yet there was a break in the action. And
But that was a guilty plea, wasn't it?
That is correct, but
So
the court
I mean,
went
that's
on-
different. If the defendant advised by counsel, getting the minutes that could substantiate multiple assaults, pleads guilty to 2 assaults, I don't have a problem with that. But I have a problem potentially if a jury is just allowed to convict someone twice over the same conduct.
Again, in Velez, the court also decided a double jeopardy claim, and in that instance referred back to the unit of prosecution and says that the jury could, or the defendant has a factual basis for more than one assault because there was a break in the action. And we don't see that this case is any different. We have the victim's testimony where she clearly testified that he punched and beat and kicked her about the face and the head. She ran away to the bathroom. He caught her, brought her back, banged her head around some more, took a break, made a phone call, decides to break up a table, beat her with the...
Yeah, I get all that. And maybe there were, I don't know how many compartments you could create out of this fact scenario, but perhaps more than one anyway. But let me make it even simpler and ask you. Supposing there had been one count only. Line 1 for willful injury, line 2 for assault with intent. And that was it. And the jury came back and found guilty on both charges. No instruction about separate acts, no. Just one count, willful injury, assault with intent, and the jury convicts on both. Well, under that scenario, of course, we wouldn't know. The jury might have found separate acts, maybe. Or they could have said, well, he's guilty of both, even though they merge. He could have had the same conduct be the basis for both convictions. We wouldn't know. And surely that would be invalid, would it not?
That's correct, but that's not the situation we have here.
Well, it's
And
very
this-
close to it here, I'm afraid. And when I look at it's not quite the situation as I think you're about to lead me, but when I look at the special interrogatories, it looks to me, or the special verdict form, it looks to me like it's stacked almost in that same way. You start with the kidnapping range, and then you have the attempted murder range, and then you have the assault range. When I look at this, and I look at the signatures here, I don't know that the jury found separate acts.
Again, I would go back to the way the case was presented. We would also direct the court's attention to the prosecutor's closing arguments, which focused on a series of assaulted acts over several hours of time, with breaks for a phone call, break for smoking a cigarette. The prosecutor understandably focused his closing argument on the greater offenses, the offense and the attempted murder, though he appears to be a little wishy-washy.
Can the county attorney change the nature of the case by saying, well, we now have separate acts here, when they weren't instructed on separate acts and they weren't charged as separate acts? That's my concern. I mean, he could argue all he wants, but we have a constitution that says you have to know what you're charged with. You have to be able to defend against that charge for the specific acts you do, and I don't think he could change it in the final argument.
We disagree that he's changing it. The defendant was charged in 3 different counts: the kidnapping first degree, attempted murder, and the willful injury. And during closing argument, as to details, The prosecutor pointed to severe head trauma from the beatings and vision damage from the nail polish remover as evidence of the defendant's intent to seriously injure.
The jury could have said, fine, that's willful injury, it's also assault, we're done.
And he also moved on to showing the photographs of all the victims' injuries and showing that those numerous bodily injuries supported the willful injury charge. We think if you take a look at the closing argument, he did separate out what acts, but the court is correct in that the instructions just said assault for every offense.
Well, whose problem is it that there wasn't an instruction that clarified that you had to find a different act to, for assault and for the willful injury in order to avoid a merger? If the state doesn't ask for it, is the state stuck with merger, or is the defendant didn't ask for it, the defendant stuck with separate sentences?
We would argue that it's the defendant's burden to ask for clarification in the instructions or special interrogatories, and I think that would be, again, more appropriate in the type of case where you're submitting alternative theories. The one case example that I've seen is the one where the defendant was convicted of first-degree kidnapping and second-degree sexual abuse. That might have been the Flanders case that the defendant cites. And
if the defendant's requesting interrogatories to the jury establishing multiple assaults, that might tend toward ineffective assistance, might it not?
Well, the point I was going to make would be that as a practical matter, the prosecutor is going to rely on different acts to support the greater offenses than lesser assault offenses, so it's not exactly clear how we could accomplish up front in the marshalling instructions that if you're also submitting lessers, and in this case there were 2 or 3 lessers for each of the 3 counts, without limiting the state's proof or creating confusion with special interrogatories added into the mix. Nor would we think it would be really workable to submit a question to jurors after they return the verdicts, like as in this case with the 2 assault convictions, because the jurors could have relied on different acts, you know, whether it be the beating, the nail polish, the cigarette, the table leg, or the fist, to find guilt on each offense. So it's just unclear how the court would go about submitting a Velez or unit of a prosecution instruction.
Is it? I take it the verdict form didn't instruct the jury to stop and not continue on if they convicted. Well, obviously it didn't, because they convicted on the willful injury and they also convicted on assault. But ordinarily, if it's a true lesser included, isn't the jury told to stop once they convict on the greater offense?
I don't recall what it said with respect to the assault with intent to inflict. The kidnapping charge had 2 lessers. The attempted murder charge had at least 3 lessers. And I believe the willful injury had a couple lessers also. So my point about, you know, how could we do this if we said under the attempted murder instruction, the kicking and beating about the head with fists and or with the table leg, then what would we put for the next one down, which the jury found was the assault with intent to inflict? This
gets really complicated if you look at the jury verdicts, because they found them not guilty of count 1, which is a kidnapping,
right,
and any of the lesser included. On the count 2, they found them guilty of assault with intent to inflict serious injury, as the lesser included of attempted murder. And in count 3, they found him guilty of as charged of willful injury causing bodily injury, and it doesn't separate which assault goes to which one. And we're supposed to speculate that the jury used separate assaults, so that's what you're asking us to do. And how can we do that?
Well, up till now, the court has focused on how the case was tried and presented to the jury and whether the record would support that the defendant committed a series of assaults in this case, or just one continuous course of conduct. And there are a number of cases cited in both our briefs. I see my time is about up. We would ask that the Court of Appeals decision be affirmed, finding that there was a series of completed assaults and that is consistent with legislative intent. Thank you.
Thank you, Ms. Hall. Rebuttal?
Unless the court has questions, I'm not sure.
Could you just respond to the state's initial argument that that this is really just a trial error that generates this appellate fogginess here, and that we should this should be a post-conviction relief type issue?
Sure. This has not ever been raised. This is clearly a merger issue. When you look at the cases with Flanders and Anderson and this series of cases, these are pure merger claims. DeLapp, the Court of Appeals case, is sort of an oddball case. He raised a lot of different arguments, and they frame one as a double jeopardy sort of merger issue, but it's really about whether he can be convicted of assault with intent to commit serious injury and assault without intent to commit serious injury, and that's raised as a double jeopardy claim. And he raises the argument that his attorney should have asked for different instructions, that he can't be convicted on sort of inconsistent crimes for the same act. DeLapp notes that the case was always tried as a series of separate offenses over the course of several days. We don't have the benefit of knowing much more details about the facts or how it was instructed or anything, because they preserved it for post-conviction in that case because his attorney didn't raise it before. But that's not what Love has raised, and that's not what this long line of cases, starting with, most recently Anderson and Lambert.
So this long line of cases that you're talking about in response to the Chief's question, I haven't read them, but what they say essentially is, if at the end of trial you have two different convictions, one item being a lesser included of the other, and if the jury could have relied on the same conduct for the two convictions, then they merge, even if it's also possible that the jury didn't rely on the same conduct.
Exactly. If it's not specified, if the case is not tried and the state didn't instruct on separate acts to support the separate convictions, it's a purely legal analysis comparing the legal elements as instructed to the jury. And there's concession that this, in several of these cases, Flanders is one, and then there's earlier precedent as well, that the state certainly could have. There was evidence in the record of multiple, say, sexual assaults, but the state never asked the jury to make specific findings that separate sexual assaults occurred or that they form the basis of the separate
And then, getting back to that question I asked you the first time you're up here, in case you have any more thoughts, because if we find merger, then the next question the state is going to have is, well, how do we avoid this next time? Because they probably won't be very happy with that outcome, given the evidence of the conduct in this case. And so the question is, is it sufficient if they delineate different things in the instructions? For example, one assault being the conduct committed by Mr. Love up until midnight, and the other being the conduct after midnight, or is it necessary for the jury to actually make the Velez-Ross findings? Do those underlying issues have to be submitted?
I don't think they have to be submitted. I think it's enough if the state tries to identify the particular acts that it's relying on. There might be argument then, as I said, from defense counsel about whether the acts that are alleged actually do constitute separate offenses. If you've got a 1 second gap in something that happens before midnight and something that happens after midnight, I think then you've got some argument about jury instructions and whether there's, again, a sufficiency claim at that point, which is not what this claim is.
Well, counsel, this
to avoid merger, then, yeah.
Counsel, this case arguably would have been fairly easy to do that. You might have isolated one assault with beating her with the table legs. You might have charged another assault when he punched her in the nose and broke her nose. You might have charged another assault with putting the cigarette out behind her ear. Another assault might have been
pouring the nail polish remover on the wounds. I mean, so it wouldn't have been that challenging
This-
here, would it?
Certainly not. Not in this case. I don't think there's various individual accesses into, as well as the states mentioned the
And to
top
follow
stop
up
for a
on,
phone call.
to follow up on Justice Heck's earlier question, it seems like it would be a bad idea for defense counsel to request a series of instructions that would break it all out like that. So,
No.
in your view, is it the state's problem if the jury isn't instructed in a way that would illuminate separate acts?
Absolutely, it's absolutely the state's burden. It's their job to prove beyond a reasonable doubt each offense. It's the state's burden, and so the state would need to identify the particular acts, and then if defense counsel thought that the instructions didn't actually identify a separate act, then defense counsel would certainly argue about that, but thank you.
Thank you as well. State versus Love is then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.